Good afternoon, ladies and gentlemen. On a weekly basis, the South African Bar Association hosts an esteemed speaker to deal with a legal topic. This is an initiative aimed at making an essential contribution to developing the skill set of all and any person who represents South African public in our courts. It is my honor and privilege to introduce today's esteemed speaker. Our speaker today is Deputy Judge President Justice Roland Sutherland. Justice Sutherland shall be addressing us on a topic titled Drafting Tips for Junior Practitioners. We are further favored to have Acting Judge Romeo Ntambeleni to conduct the welcoming and conclusion of Justice Sutherland. In terms of housekeeping, these sessions are recorded. An appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. In that regard, during the address, all participants shall automatically be muted. Should a participant have a question, simply raise your hand using the Microsoft Teams platform. Alternatively, type your question within the chat box, and such question shall be put to Justice Sutherland. During the question and answer session, a humble request is made to restrict questions to the speaker relative to the topic under discussion and only pose such questions when called upon. Without any further ado, I now hand it over to Acting Judge Ntambeleni to conduct the welcoming of Justice Sutherland. Over to you, Acting Judge Ntambeleni.
Yes, good afternoon, legal practitioners and all in our division, everyone who's joining us. Good afternoon. It's a wonderful opportunity for me to introduce to you our DJP in our division, and as you will know, it will be a very long introduction, but I'll try and keep it short. Given his long career and the stint in our profession, I'll try and make it short. Judge Sutherland began his career as a clerk of the Magistrate Court in 1968 to 1962, and then he became a public prosecutor at the Regional Magistrate Court between 1974 and 1975. And he also was a public prosecutor in Specialized Industrial Court from on the province of Transvaal. In 1975, he became a state advocate in Johannesburg and Pretoria between the period of 1976 and 1977. He became a member of the Johannesburg Bar in 1977 to 2011, and during 1995 he took silk, and then he became a legal counselor for the urban training project and labor law clinic between 1978 and 1980, and arbitrator and mediator and independent mediator services of South Africa in between 1987 and 1995, and then small claim courts commissioner in 1985 to 2011. He became an acting judge of the Johannesburg High Court on several occasions between 1997 to 2011, and the acting judge at the Labour Court on several occasions between 1997 to 2004. And then he also became the judge of, a full-time judge of this division, our division, and at the period of 2012, and the acting deputy judge president of the division between 2019 and 2020. Was the judge at the appeal court in the Labour Court in 2014, acting judge at the Supreme Court of Appeal at the period of 1 June 2020 to 13 November. And ladies and gentlemen, I introduce to you our DJP in our division, Judge Justice Roland Sutherland. Thank you very much.
Well, good evening, everyone, and thank you very much for that very generous introduction. May I compliment the SA Bar Association on these lectures and the very nifty technology I see is used to conduct these things remotely. Well done, and I congratulate you on your initiative and the quality of the output which you've managed to put together. This is really a major contribution to continuing legal education amongst the profession, and can only serve the interests of the judiciary no less than the profession, and I'm honoured to be part of your program. So let me move to what we want to talk about tonight, which is the drafting of court documents. And the aim of this lecture is to try and encourage everyone to develop a mindset that appreciates the need for a strategic approach to the drafting of court documents. So in the spirit of advocacy training, I give you the headline. Documents are tools, and counsel are the crafters of these tools. That's the thought that you need to go away with and fall asleep tonight. This is one of the most critical insights into this particular aspect of professional practice, because everything that you write and transmit for use in a court is not some end of a process event. It is the beginning of a process. And your documents are tools which you have to use in court and which the judges and magistrates have to use in court. And so you need to create them and shape them in order to have that effect. A crafter of a tool clearly must understand what the specific job in hand is. And that's one of the themes I'm going to hammer away at tonight, is that counsel have to be reflective. You need to think carefully about what you're doing. Don't be hurried. Don't be hassled. When you produce something of professional quality, it deserves a second look, it deserves a check. And those who will be the recipients of your advocacy, the consumers of your advocacy, such as judges and magistrates, are entitled to expect you to have done a professional job in presenting to them what they need in order to do their jobs. This tool that we're talking about, and we'll get to what those documents are presently, has to work for you and it has to work for the court. If you can get it right to work for both of you, you will be halfway home to presenting the kind of presentation that will build your careers, because you will achieve market credibility through the judges and the magistrates learning that you are an exemplar of professional work, and they will have confidence in you to present professional work when you visit them again and again. So now in concrete terms, what are we talking about? Here are some generic considerations, and we'll drill down into the detail a little later on. First, you need to draft the particular document with your mind focused on how you will use it in court. That is to say, the tool. That's the point I've been making up to now. Secondly, do not draft a document that you do not understand. You must understand your own case before you start drafting. You can't just plow into a document and waffle along hoping that the point will emerge somewhere. You are engaged in an exercise of analysis and exposition. And those are watchwords you need to engrave on your forehead in every document that you create. You are not writing a novel. There is no value in a surprise last chapter. What you're doing has to be clear from the beginning to the end. One of the areas where a failure to appreciate this is most evident is typically in RAF claims, where plaintiffs' counsel draft the details of the basis for damages, where they just lift text out of the doctor's report without any comprehension as to what this jargon means, and produce page after page of waffle that no one understands and no one reads, because it is too arcane, too dense, and too obscure for anyone to make use of. It's a habit that you must escape from. Don't take shortcuts by simply replicating text which is given to you. You must understand it. You must rework it in language that you will understand and you will be able to defend when you stand up in court. Don't just pour jargon out of a jug like treacle into a cup. Thirdly, you've got to structure your document so that it's coherent and that you can navigate your way around it. If you have to fumble your way through pleadings or through affidavits or through your heads of argument, so will the judge, and it will really undermine the very purpose of you being in court and using this particular document. You must be sure that what you've drafted is an accurate reflection of your instructions. Now, it's an occupational hazard of counsel that frequently they get inadequate instructions. Do not skimp on getting adequate instructions. You must note them properly if you take them from a client yourself, or if your attorney sends you instructions and they are blanks, or they are fragments, or they are inadequate, or they overlook things. Do not be too timid to go back to your attorney and expect better instructions. Sometimes junior advocates, particularly in your first couple of years, assume that attorneys know what they are doing. That is not an assumption that you are entitled to make, no matter how senior the attorney is. The very existence of the counsel's role is to check and protect the attorney from any oversights which may take place, however experienced that attorney may be. Your job is to have your attorney's back, and you do that by being bold in pointing out deficiencies which you see. You will build market credibility with your attorney by being bold enough to do so. You will win no kudos by simply being a minion that carries out the attorney's instructions uncritically. Next, you have to ask whether or not what you've drafted is unambiguous. Frequently that's overlooked, often because one is hurried when drafting something. It's a terrible, terrible danger. Drafting ambiguous documents in pleadings will provoke exceptions. In affidavits will provoke embarrassment when it comes to arguing whether or not you have covered a particular point or not. And particularly if it's better dealt with in the answering affidavit and you want to come back with some better articulation of the point you haven't made properly in the founding affidavit. You must be very careful about that. Next is what you have drafted. Is it contradictory? Especially in relation to the annexures which are attached to pleadings. When you have pleaded an agreement and you've attached the agreement, is what you have said in the pleading a true reflection of the terms of the agreement? It's no good just quoting text and then overlooking the implication of a particular paragraph in the agreement that has a material bearing on what you've said. You must understand the whole agreement so that you can accurately reflect what the agreement is and not misrepresent what it is, because you cannot succeed on that basis. You will be found out and it will be an embarrassment. The next thing you need to check is whether or not you've padded your document, typically in an affidavit, with unnecessary waffle. It is critical that you keep your documents as short as possible. I'm going to have something today say something shortly today about the attention span of the court. You have to bear that in mind. Next is, have you written your document in jargon-free language? Using fancy words, lots of adjectives, are usually an indication of a lazy drafter or someone who hasn't understood their case. You must use simple language that gets your point across in a way that whoever has to read it will understand it. And then lastly, is your document structured in such a way that it can be used as a tool of persuasion, the ultimate objective of every drafting exercise? And we'll look at all of these in turn. I'm not going to look at every document that counsel will be called upon to draft. I'm going to ignore petitions to the Supreme Court of Appeal, opinions, advices on evidence, which have their own peculiarities. And I'm going to focus on the kind of documents that you would typically and often prepare to go to court in Gauteng. And that's particulars of claims and declarations, a plea, further particulars, an exception, notice of motion, the founding affidavit, the answering affidavit, the replying affidavit, heads of argument, which is a very critical document, and then two things you might not have thought I would address, but are important in this context. The one is counsel's role in settling expert summaries and joint minutes, a much overlooked aspect of practice, and the formulation of Rule 33(4) orders when you want to separate an issue and have it adjudicated on its own. So let's move forward then to deal with these various kinds of documents. First of all, pleadings. If you're going to start pleading, the first thing you need to know is that the rules of court govern what you are obliged to do and what you cannot do. It's quite apparent from many pleadings one reads that one has reason to doubt that the pleader has even been aware that in the Uniform Rules of Court, rules 18 to 22 are critical. You must study these rules, get hold of Erasmus, and take time out to learn these rules backwards and study the commentary, which is full of very useful case law on how these rules apply. It is the beginning of your comprehension of pleading, and you cannot begin to start pleading strategically until you've mastered those details. I'm going to touch on some of the key things that appear in the critical rules between Rule 18 to 22, but there's much, much more there. And if you have a serious intention of being a mature practitioner as time goes on, you must master these particular rules and the case law that goes with them. So let's just look at a couple of perhaps obvious but devastatingly important things which are frequently overlooked. In Rule 18, which deals with pleadings generally, one is told a very, very important thing. Your pleadings must be clear and concise. Your pleadings must illuminate your case, not obscure it. The reason why some pleadings are obscure is because whoever pleaded it did not understand their case. If you understand your case, you will be confident enough to state it in plain language. And if what you have written looks like gobbledygook, you must tear it up and start again. It is part of your job, part of what will secure you a professional reputation, that you can plead clearly and concisely, and there will be no ambiguities. Secondly, Rule 18 tells you to plead only the material facts. You must not put evidence in. You must not argue. You must identify what the material facts are and make those allegations, not try to sneak some kind of justification in. That comes much later. If we look at Rule 20, which deals with declarations, but has in certain respects the same application to particulars of claim, the first thing you need to do in drafting any document is to know what you want from the court. And that's no more important than in the prayers you put in the order you pray for. What do you want from the court? You cannot draft your pleading until you've drafted your prayers. You have to draft the prayers, examine them critically, ask, can I get this in law? If not, then you must reformulate. Once you're satisfied that what you're asking for is what lawfully can be granted to you, the next thing you need to ask is whether or not what you have asked the court to order, should it be necessary for the sheriff to go and execute on it, the sheriff will know what he's got to do. Very often, both in pleadings and especially in notices of motion, what is asked for is so obscure that were you to be granted it in those terms, the sheriff would be unable to know whether or not there'd been a breach, if he's going to go along and deal with the enforcement of a contempt, or indeed even to execute on what was done. You must be very clear that your prayers end up in an order which is a tool which the sheriff needs to use in order to do their jobs properly. Then when we come to further particulars, here's an area that I want you to, in particular, take care to reflect on what you're actually doing in this particular aspect of putting pleadings together. Many requests for further particulars are quite frankly rubbish. You must discipline yourself to ask only real questions, not pepper your opponent with all kinds of nitpicking nonsense. It impresses no one, and it can only undermine your professional reputation. When you do have a real question to ask, don't make it cryptic. If, for example, you've got a case in which you want to know when something in particular took place. In your question, don't say, add paragraph 3, at what exact time did it occur? Because when the reader of your request sees that, it has no idea what you're talking about, and you now have to read the particulars of claim in conjunction. Make it more reader-friendly by framing it rather this way. Add paragraph 3, at what exact time did the fire alarm go off? Then the reader comprehends what is necessary. Make it user-friendly. When you have intelligible requests, you can then demand intelligible responses. And the same point I make here about the question is even more important about the answer. Don't give cryptic answers that are meaningless without cross-referencing to the particulars and to the request. Formulate the answer entirely. The exact time at which the alarm went off was 13:10 on the X date, so that when the reader of it, particularly the judge who hasn't had any introduction to the matter beforehand, can comprehend at once, without wasting precious seconds fluffing around, looking for other documents to see what the answer really means, it can be comprehended at once. One of the really good ideas, not used often enough, is particularly when there are a lot of particulars, long pleadings and further particulars, is to create a table on an Excel spreadsheet where all the averments in the particulars of claim and the averments in the plea can be tabulated side by side. So the judge can read the pleadings simply on one page from left to right and see exactly what's been alleged and what's been denied. And the same thing goes for particulars of claim, or rather further particulars. Have the questions and the answers side by side so that they can be read quickly and comprehensively and can be digested because they're user-friendly. An interesting point seldom thought about is, what are the ethical constraints in pleading? Now, in the Code of Conduct of the Legal Practice Act, and also not in the Red Book of the General Counsel of the Bar, is any reference made specifically to pleadings. Certainly some other norms do apply, and I'll mention them in a moment. But one of the things that you need to bear in mind is that from time to time, there are ethical considerations in what you need to say or not say. As in all documents, you must not have invective. You cannot insult people, and be very careful about what language you use in order to deal with things. But there's one particular case that I want to draw your attention to, and you should make a note of this if you're not aware of it. Standard Bank factors versus Ferncore agencies. It's reported as 1985, 3 South African law reports, 410 in the Cape. That's the leading authority on pleas in regard to denials or non-denials. In every allegation to which you plead, you must either admit or deny. But sometimes you have no knowledge of the averment. It is wrong to deny. What you need to say is, I have no knowledge, or the defendant has no knowledge, and you put the plaintiff to the proof. There are serious implications for this, because if you do say no knowledge put to the proof, it means that the plaintiff is entitled to prepare his or her case on the basis that there will be no rebuttal to evidence which supports the averment. If you turn up and want to rebut it, you'll be in trouble because your pleading would have misled not only your adversary, but also the judge in regard to what is common cause and what is not admitted and so forth. So be very careful about that. Then let's move on to applications. To a large extent, of course, much of what I've said of generic nature applies to applications as well. But there are a number of peculiarities in affidavits which we need to be conscious of as well. First thing you need to digest, and this is sometimes not properly appreciated, is that affidavits constitute both pleadings and evidence. It's a synthesis of both. And the authority for that you need to know about is Lowe, L-O-U-W, Lowe and others versus Nell. And it's reported in 2011 to all South African law reports, 495, an SCA decision. Let's move now to notices of motion. Every exercise in drafting must begin with what you want from the court. You'll have heard me say that, and I'll say it again many times this evening. It is an absolutely critical thing you need to digest. Until you have achieved absolute certainty, you cannot know what you want to say in your founding affidavit. So once you've formulated your notice of motion in the same tone that I've addressed the prayers in pleadings, is the order competent in law? Can the sheriff execute it? And what facts do I need to allege in order to support that relief? That particular analysis, what facts do I need to put in the affidavit to support that relief, is a critical part of your thinking, because it is only those facts that must be put in. If you put in facts which are irrelevant to the support of the relief, you are then putting in waffle. Once again, I say, you are not writing a novel. You're engaged in an exercise of analysis and exposition. So if we go to the founding affidavit, there you need to put out the facts and only the relevant facts, not argument. If you have to refer to a legal principle, which occasionally is appropriate, then you identify it, you quote the statute you're relying on, or the common law principle, but you don't inject into your affidavit the argument that you will later appropriately put into your heads of argument or argue on your feet. You need to bear in mind that what you are writing in the affidavit, in capturing the facts, is the justification for the relief sought. So when you begin your founding affidavit, it's always useful to introduce to the reader of your founding affidavit your destination. Where are you en route to? When you do that, you give the reader of your affidavit an opportunity to know what to look for as you read through the 20, 30, 40, maybe 100 pages. The longer the affidavit is, the more important it is to make sure that it's really readable. You need short paragraphs, one idea per paragraph, even if it's just one sentence. That's better than putting a whole lot of ideas into a single paragraph. When you do that, you make it very difficult for the other side to answer the paragraph coherently. You need short sentences, simple language, active tense. We've heard this all before, I'm sure. And use theme headings in your affidavit so that as each section, when you move to a new theme, it's clear to the reader and one can absorb each theme coherently as you go through it. To get an affidavit that runs to 50 pages with no headings leaves you with a kind of stream of consciousness presentation, which is very irritating at worst and unhelpful at best. Always bear in mind your reader's attention span. A tired judge is your greatest enemy. You must bear in mind that the attention span of the court has to be borne in mind. And then annexes to affidavits, founding affidavits or any others for that matter. Are they really necessary? Often reams and reams of documents are attached to affidavits that are never read, never referred to, and are utterly useless. They're put in there because counsel and attorneys are hurried or too lazy to make the distinction, or have not understood their case well enough to be confident to know what they can leave out. You must have thought through your case before you finalize your documents. And if you do have annexes, you must properly describe them in the affidavit, and you must properly and accurately cross-reference them. And please, do not annex annexes which are illegible. It serves no purpose whatsoever. If you have documents which perhaps you have a poor copy or the print is too small, the answer to the problem is, as in the Supreme Court of Appeal, where there's an express injunction, you have copies of legible, in legible form, which you address, where you include as page 23A, B, and C. And then the judge can actually read what he or she is required to look at. Because an illegible document, which you need to have read in relation to what you say in your affidavit, cannot be read, and the point you want to make will be completely lost. So let's have a look now at answering affidavits. It's becoming increasingly the habit, instead of answering the paragraphs in the order which they appear in the founding affidavit, is to introduce the answering affidavit with a long preamble narrative setting out the whole case, and then to perfunctorily give brief remarks to each paragraph in the founding affidavit. This is not helpful, and very often it is not necessary. Occasionally it will be necessary for you to have a narrative as an introduction, particularly where your case as defendant or respondent is chalk and cheese with what has been set out in the founding affidavit. And if you need to do that, you've got to be absolutely particular about cross-referencing what you are saying to the averments which you are rebutting in the founding affidavit. You can't end up in the second part of your affidavit saying add paragraph this, that, and so forth. This has been addressed above. That doesn't help the judge. The judge is not in the position to have the time to go trawling around looking for where you might or might not have dealt with something. If it's important enough to deal with, it's important enough to cross-reference to where the contending averment has been made. And if you do that, the judges will love you, and you will promote your professional reputation and enhance your market credibility. If you don't do so, the judges will have exactly the reverse attitude towards you, because you have made making that judge's job that much more difficult. When you draft an answering affidavit, you must be aware of the implications of what you say in it. If you introduce matter which you know is going to attract a reply, one of the things that you ought to try and do in order to avoid you having to file a fourth affidavit is to deal with it in such a way that you won't have to come back after the reply. This is one of the strategic objectives in drafting your answering affidavit. Also, you need to be quite sure that what you say in your answering affidavit is necessary. If you're going to introduce a fact which is not necessary, but will provoke a tangential argument with a reply and then the need to rebut that in a fourth affidavit, you need to avoid that. Do not be cavalier about what you say in your answering affidavit. It is, as I've said, a tool. It's got to work for you, it's got to work for the judge, and its function is to rebut what has been said in the founding affidavit, or to answer by way of an admission and then an explanation. Often when answering affidavits serve no more than to say, it's true, everything you've said is common cause, but here is my story. Then you know that there's going to be a reply to that, and you need to anticipate whether or not you can avoid having to come back with a fourth affidavit. Do not be coy about such things. Think it through strategically. Then we come to replying affidavits, probably one of the most useless things that counsel engage in. The proper use of a replying affidavit is to rebut material which has been raised in the answer, which you could not cover in your founding affidavit. It is not there for you to repeat and to take page after page after page to say denied as set out above and so forth. Only use a replying affidavit if you really need to, in order to rebut what you didn't deal with or could not deal with in your founding affidavit. Most replying affidavits are never referred to in argument. and even more are not even read by the judges because there's no anticipation that they will provide anything useful. In regard to the point I made about pleadings about ethical considerations, there's one particular case that you ought to know about because there's a liability which you expose yourself to when you settle affidavits. You cannot settle an affidavit, whether you're an attorney or counsel, by putting into it facts given to you by your client, which you know as a fact are untrue. We don't have to believe our clients. In fact, it's wiser never to believe clients. But if you know something is said by your client to be untrue, as distinct from merely suspecting that it may be untrue, you may not put it in. And if there's any doubt in your minds about that, go and read this case. Van der Berg versus the GCB. It's reported in 2007, 1, All South African Law Reports, 499 SCA. There, a Silk at the Cape Town Bar did exactly what I've described, and this is the case for his striking off. And secondly, as with pleadings, no invective. Never be insulting, however horrible the other fellow is. Strategically, last word on applications, remember there is no onus in applications. Don't draft documents in applications on the mistaken assumption that the onus applies. Plascon-Evans is the case you need to know backwards, and if you don't remember what Plascon-Evans says, go and read it every time before you draft an affidavit. It's absolutely critical to getting across your point properly and sustaining your professional reputation. I'm now going to move to heads of argument. Heads of argument are a critical tool for all the reasons which I have already enumerated. But what's particularly important about heads of argument is that they win cases. Good heads win cases, bad heads lose cases. And you need to inscribe that on your forehead. But now the content of good heads, what does it have or what doesn't it have? For starters, good heads are not decorated by a plethora of authority. In 2021, no one needs to know what was ever said in Griqualand West local division. If you have a proposition and the Constitutional Court has laid down the principle, I don't need to know what the Transkei Court or the Mpumalanga Court said about it. One case is enough. The top court is the authority you require, and all the rest you can leave out. One of the biggest flaws in heads of argument is the tendency of counsel to offer reams and reams of case law and neglect the facts. The most important part of heads of argument for a judge is how counsel deals with the facts. If you don't deal with the facts properly, the judge has to go and do that exercise, him or herself. And if you want your propositions to be accepted and to be persuasive, you need to present to the judge in your heads of argument your analysis of the facts. One of the areas where this is appallingly done on a regular basis is in criminal appeals from the Magistrates Court, where counsel give us cut and paste stuff of apple pie order, but hardly tell us anything about the facts, especially on sentence. To know what various statutes say and what the minimum sentences are, etc., and what Hammurabi had to say about it, is of no value whatsoever. What one wants is a considered and mature evaluation of the facts so that one knows why the particular principles which are relevant ought to be applied in a particular way. One of the most useful tools as an annex to heads of argument is a chronology. And a proper chronology is one which refers to the events in a neutral fashion. Don't try to make your chronology part of the argument. Properly cross-references it to all the papers, both yours and to your opponents, and The best kinds of chronologies are the ones where both counsel agree on it. So they're a joint neutral chronology. It's very irritating to find two sets of chronologies because counsel have wanted to slip in their own slant on events, and so no one can agree on a particular version. So that's generically what we're looking for in heads of argument. Now let's look a bit closer on the content. Heads of argument have three parts. First part is the beginning. And here, once again, if there are only a few things you go home with tonight and fall asleep with, remember this. The first part of a heads of argument, when you introduce what you're going to argue about, you want to tell the judge where you're going. And you need to pose to the judge the very questions that you are asking the judge to decide. Once you've told the judge that, the judge knows what to look for as the rest of the heads are read, and when he gets down to reading the record or the affidavits, he understands the propositions which you have asked to be decided, and he or she knows what to look for. It's absolutely critical that you do that at the beginning part of the heads so that it becomes a usable and effective tool. Then we have the middle part. There, the facts have to be captured, the critical facts. There must be accurate references to the record. Very often, there's very poor proofreading, and we get the wrong reference to the wrong paragraph. Check for accuracy. Get your attorney or your junior or a colleague or a clerk to check the references for you, because often there's an inadvertent misrepresentation and you can create the wrong impression, especially in regard to appeals, where lots of evidence covering the similar point occurs, and sometimes there's a mistake in referring to one passage that alludes briefly to what you want to say, but the critical passage is somewhere else. As far as the law in the middle section is concerned, do not quote trite propositions. No one reads it. We all know what the test is for interpreting a contract. You don't have to cite Judge Wallace's dictum to us anymore. We all have it imprinted in our memories. When you do have to quote case law, it's when you need to argue the construction, because there's a contestation about what the dictum means, whether it does apply or not, and you want to distinguish something. Or alternatively, you want to quote the particular dictum that is the all fours application for the particular facts, which you've already crafted in a coherent fashion. Then there's the end. When a judge has gone through your heads of argument, one of the things the judge will ask is, what does this litigant want from me? And so tell him, set out the very order that you want, which conforms with all the norms I've been talking about for pleadings and for notices of motion, so that the judge understands exactly what he or she is being asked to order. If you do that, as I've said once before, you will make the judges love you. Those are really the primary documents which you need to really become quite adept at doing. But there's a few other things that I want to mention about what you might not necessarily think as documents which counsel draft ordinarily. The one is in settling expert summaries and joint minutes. This is particularly important in our division because our Directive 1 of 2021 deals with what you need to present both in case management hearings and at court as regards expert summaries, which have to be in paragraphs and cross-reference to other expert summaries, and the joint minutes have to conform with having set out exactly what is agreed, what is disagreed, what is clinically observed, what is an inference drawn. You must check these things for these purposes, and it would be good practice not to leave it to the doctors to do the final summaries, Once they've done their reports, they should be submitted to make sure that they have complied, and you need to settle them. Then the last document I want to refer to is Rule 33 for separations. They're often very cavalierly done. It's important to formulate them in neutral terms, in the same way you would do at the beginning of your heads. What is the question which the judge needs to answer? You formulate that in a neutral frame so that the judge knows what's required and both parties need what cases to prepare. If you take time out to formulate those things clearly, you will advance yourself enormously. And then the very last thing I want to say about drafting documents is the implications of case lines, which many of us have had to get used to after many years of doing things in other ways. And for the more junior members, that's the only way you've known. The biggest thing in case lines to overcome is the ability to easily navigate your way around all the documents. There are directives which tell you what you have to do, and it's very important to have indexing done in an absolutely apple pie fashion. You need it so that you can navigate your way through around the papers, and so does the judge. But importantly, in drafting your heads of argument especially, you must use case line pagination. It's no good using an alternative set of pagination or paragraph numbers when that is not how the judge is going to be able to find it on case lines. Cross-referencing has become absolutely critical in this medium so that it can be navigated easily. So please bear that in mind. It means, of course, that you have to go back and edit documents which you would initially have drafted without such references, but that's just part of what we need to do now in order to effectively practice under those circumstances. So having said all that, let me leave you with these general thoughts. When you're drafting documents, you need to think carefully before you start drafting. When you have drafted, you must check frequently. And when you've got to a point where you think you're finished, you've got to ask yourself whether or not you have acted strategically. And if not, you need to go back and make adaptations. If you do that on a regular basis, you'll find that you will be making good tools out of your documents, and your advocacy will be all the more effective. So good luck with that.
Thank you very much. Normally, this program runs from 4 o'clock to 4:30, and then there is normally a Q&A answer. But given the importance of what you were presenting today, there was not even an inkling of a chance that one will interject you in what you were actually assisting. And I believe that all that who have ears will have actually heard, and they will use this because we have a recording to actually cross-reference while they are actually doing their work. And then for now, we'll ask you if it's possible for perhaps an extra 15 minutes of question and answers. And then if we are done, then we will then be all excused. But thank you very much for such wonderful presentation that you presented today. And we also look forward to hosting you also in future as well.
Thank you very much. I'm happy to stay on as long as there are questions. So I'm not in a hurry.
Okay. And now I move over to AJ.
Justice Sutherland, speaking on behalf of the South African Bar Association, all the participants, as well as those that will be watching your address at their leisure, I can confidently say that your address was remarkably informative. I have now opened the platform for a brief question and answer session. By way of reiteration, to those participants that have a question, simply raise your hand using the Microsoft Teams platform, and when your name is called, simply allow your mic and or your video to pose your question directly to Justice Sutherland. Alternatively, you may type your question within the chat box, and such question shall be put to Justice Sutherland. I shall initiate the question and answer session. or a comment, and thereafter a question. My comment is in relation to the use of plain language. I refer you to a submission made by Acting Judge Ntambaleni during his address on the 24th of June 2021. Acting Judge Ntambaleni submitted that it is important that the message in pleadings is delivered in a proper and plain language. He further submitted that the days of legal jargon are over and we are moving into a future where the legal principles must be brought down in a language that people will understand. Accordingly, your submission in that regard is concurred by Acting Judge Ntambaleni, and I humbly request that Acting Judge Ntambaleni elaborate further on his previous submissions in this regard. Moving to my question. My question relates to the position in law regarding the limitation of the discovery rules of court against the right of access to information. Now, Section 32 of the Constitution recognizes that everyone has the right of access to any information held by the state and any information that is held by any person that is required for the exercise or protection of any rights. The Promotion of Access to Information Act was promulgated to effect, or rather to give effect to the realization of this right. Now, in terms of Section 72 of the Promotion of Access to Information Act, it does not apply to records required for criminal or civil proceedings after commencement of proceedings where access to that record is already obtained for whatever reason. Where records are obtained in contravention of this exception, they are admissible as evidence in criminal and civil proceedings, except where a court determines such exclusions will be detrimental to the interests of justice. Now, my understanding is that the reason for this exception is to allow the law of evidence and civil procedure to apply to criminal and civil proceedings. In civil litigation, part of the process after close of pleadings is to request documents for discovery. A number of cases have suggested that the Promotion for Access to Information Act was never meant to be invoked as a replacement to the discovery procedure. Now, while the jurisprudence from the courts have ultimately found that the Uniform Rules of Court is an exception to the scope of the Promotion of Access to Information Act, a minority judgment of the Supreme Court of Appeal in the Unitas vs. Van Wyk case, if I'm not mistaken, has suggested that the distinction on when the Promotion of Access to Information Act or the Uniform Rules of Court should apply, which are not that clear. In view of such, Justice Sutherland, what is your comment on whether Section 7 of the Promotion of Access to Information Act limits the ambit of the constitutional right to access, let me rephrase, on whether Section 7 of the Promotion of Access to Information Act limits the ambit of the constitutional right of everyone to access information?
Well, my short answer is I haven't thought about the question and I don't have a considered view. What I am aware of is that the law is in a state of flux. What I do foresee is that the contestation between the scope of discovery and the scope of PIA is probably going to be resolved when the Constitutional Court has to examine whether or not there will be certain forms of information that fall between two stools and whether or not there is any abuse present. My saying that is based on the fact that that's the way I understand the Constitutional Court's approach has been to other procedural considerations. They will endeavour to keep it an open question and to have the ultimate answer reside in a discretionary zone in order to avoid any failure of the interests of justice. Now, the interest of justice doctrine has been used over and over again by the Constitutional Court to open up places which were previously shut. And that is the most likely doctrine on which they will start poking around in this particular area. But as far as a direct answer to your question is concerned, it's not something I've worked through. And I can only really offer those thoughts as a generic response. to where I think the development of the law is likely to go.
Thank you so much.
For me, just to comment on what you have actually said, I think we cannot replace reading from lawyers. Reading helps you in understanding your case, and we have seen it most time in papers where people are using Facebook language and social media languages, and that is completely discouraged. So you ought to read and understand your case, and this is what Justice Sutherland has been emphasizing. For young and up-and-coming lawyers, there's no shortcuts to lawyering. If you don't want to read, go somewhere and do something else. Go and open a barber shop and cut hair. Here it's about reading and understanding your pleadings. And as much as you want to be heard by the court and to be listened to court, you must present a coherent argument based on what Justice Sutherland has been saying, that when you have properly prepared your case, it's going to be very much easy for you to actually present it in court. Don't try and use Latin where it is not necessary, and try and be fancy and use an 1800 language thinking that you're going to impress your opponent and raise unnecessary objections. This is not a soapy. It's a real court. You don't wear that gown just to impress your friend. You must be worth the gown that you're actually wearing. That's all I'm going to say.
Thank you. Thank you so much on that comment, Acting Judge Ntambuleni. Justice Sutherland, there's a question from, please forgive me for my pronunciation, it's Velikazi. I'm going to read it verbatim. Dear Judge, is it more appropriate in heads when applying case law to deal with each point and or fact of your case under that part of relevant law, or is the judge's preferred position that all the case law be in one section and application be begun after that? I appreciate your response.
Yes. There's no real rule on that. What I think you need to do is to develop a sense of strategic awareness. Sometimes it will be helpful if you deal with all the facts in one section and all the law in another section, but not necessarily so. You may deal with, let's say, 3 or 4 factual issues where there's a contestation with the other side, and you may want to invoke a legal principle to assist you in some or all of them. Then you would cite the relevant law in regard to what's been done there. The really key insight, I think, is that you want to deal with each topic coherently, and then when you're done with it, you move on to the next topic. What you don't want to have is your reader have to look in 2 parts of your head to understand the totality of your argument. Sometimes, for example, there's a big legal question which can be dealt with discreetly, and then you can put that in its own section. But where the law and the facts and the application of the law, and whether in fact there's a distinguishing factor which makes that particular case not applicable in this thing, then the place to deal with it is when you've dealt with the facts, because that's one set of, or rather one chain of reasoning which the reader is going through at the time. So you've got to use your discretion, and you can't fit your heads of argument into a one-size-fits-all model. Similarly, the way you would draft your heads in an opposed application is not necessarily the same way you would deal with your heads in an appeal. You have to adapt, and because this is not a slot machine exercise where you can have a tick box approach to how you produce the result. Remember, heads are never a ritual, although sometimes you read heads and you think that's what was intended. You have to adapt each particular tool to the particular job that it's got to do. And there may be differences that are great or differences that are small, but that's the craft that you're practicing. And it's got to be ad hoc and tailor-made to the particular matter.
Thank you so much, Sutherland. There's a question from Leon Peter. Leon Peter, you can simply unmute your mic and or your camera.
Thank you, AJ. Good afternoon, Judge.
Hello.
Judge, my question relates to, in fact, what you've just said about heads. And I've heard what you said about tailoring the tool to the job that it's meant for. With particular reference to opposed motions, which is what one deals with most often in the High Court, is there, I know there's not a limit on the length of heads, but is there sort of a guideline? I know you'll be guided mostly by the facts of your matter, but is there sort of an estimate where you can stick to the facts and try not to palaver and bore the judge? That's the first thing. And also, at where does one strike the balance between just limiting the heads to just the factual matter or introducing written submissions? Because sometimes you stick to the heads and then you get to the court and the judge says, well, that's not in your heads. That what you're arguing is not in your heads.
No.
Thank you.
That's a fair question. Once again, there's no hard or fast rule. Generally speaking, shorter heads are better than longer heads. But one mustn't be timid and be afraid of having long heads when they're called for. If you've got to take a couple of examples, let's take a credibility issue. Credibility is always decided on probability. And in order to determine the probabilities, you have to go through the detail. And so your heads are going to be longer if you had to deal with credibility issues. That's just inevitably so. When you've got a situation where the facts are common cause and they can be briefly described, and what the real controversy is whether those facts satisfy a test, either a statutory rule or a dictum in the case law, then having set out what the common cause facts are, you need to now extrapolate why the particular rule or dictum is applicable. That may require you to go into cited parts of that case law and demonstrate that this is exactly what in that case was contemplated, or if your case is the other way around, why this is different. So you drill down into quite a lot of detail. Long heads that engage with detail, both as to fact and as to the text of statutes or cases, are perfectly acceptable and wholly appropriate. What needs to be avoided is the decoration of heads so that they look impressive. And that's the kind of abuse that you need to avoid. Ultimately, I suppose one can't say this strongly enough or often enough. The critical thing with heads of argument more than anything else is, unlike pleadings and affidavits, where it is the client's case speaking, in heads of argument, this is counsel's voice. And we'll all develop a particular style depending on our own disposition and the way our own analytic approach to the matter differs. And you will develop a particular style of your own, just as you develop particular styles of addressing the court. One of the things that is fascinating to observe over time from a judge's point of view is how similar cases are argued so differently by different counsel. Not to say that the quality of the argument differs, or one is much better than the other, but everybody has your own particular style of how to present things. And you mustn't try to ape someone else's style. You may admire a colleague, some of the great maestros of advocacy, but don't assume that if you decide that Sidney Kentridge is the best thing next to ice cream, that you have to now develop a similar demeanor and a similar way of writing. The thing that's important with argument is to be genuine to understand what the consumer of your advocacy, the judge, requires, and to be sensitive to how to make that connection. And the length or shortness of heads of argument are only an aspect of that.
Thank you, Judge.
Thank you, Justice. There's a question from Kaswayo. I'm going to read it verbatim. My question is based at a student level. I am doing my penultimate year and we are being taught drafting skills. You mentioned that there is no need to regurgitate tests of which the courts are familiar with. However, in university, we are encouraged to enlist all but necessary points to, in inverted commas, aid our arguments. How do you reconcile the point you made with institutions teaching the LLB degree?
Well, first, I'm not familiar with the particular curricula which are being used in universities, and I don't know whether or not the particular lecturers who are conducting those lectures are or ever have been practitioners. So one would first of all want to know whether someone is approaching pleading from a totally academic but unschooled approach. I'm of the view that the best way to learn pleading is to do it in the trenches of practice. I have my doubts about the extent to which universities can do anything more than teach the basics, and I certainly support them doing so. I know from my own experience when I was a student in the early 70s at WITS, at that stage they always had practitioners from the bar come and teach pleadings. And so what one was getting was instruction from people who were making a living out of doing what they were teaching. You can only imagine how incredibly valuable that was. And one of the great privileges I enjoyed was to have Michael Cooper come and teach me how to plead when I was a final year student. What I imagine the universities generically are concerned with is to conscientize students as to the legal requirements, the basic need to be articulate, clear, succinct, and so forth, and to observe what we might call the learned dimensions of pleading. What I've spoken about tonight, of course, is a voice from the trench rather than an academic view. So there may well be some differences in approach. Ultimately, I can't imagine that there's serious contradictions, but what I think one benefits from as a student is not trying to run too far ahead. It's important, I think, to have a very solid academic basis for what's going to become your professional life. And one must savor that and one must absorb that. And if that means when you get into practice, as inevitably has been many people's experience, you need to do a little bit of unlearning, there is no harm in that. Because, as I've said in reply to an earlier question, advocacy is a very varied skill, and you need to work out your own particular individual style. And provided that you have a solid foundation in the basics, you can confidently develop your own particular approach. So I would absorb whatever you're being taught, understanding that it's the beginning of a learning process in pleading, and you'll make your own adaptations in relation to your own experience when you get into practice in due course.
Thank you, Justice. It's a question. I'm going to read verbatim. Judge, with the different drafting styles, would it be best to start with a brief introduction of what the matter is about, that such as an introduction provides the judge with a snapshot of the case and also directs him or her on what issues to focus on when perusing the pleadings.
That is always a good approach. And of course, in this division, we have practice notes, which counsel provide for opposed motions, for appeals, even for trials. And a practice note, which normally speaking should never exceed 3 or 4 pages at most, excluding all the blah of the heading and so forth. That's fine. One of the things that, if I can inculcate it into you tonight, is important, is judges need to know where they're going when they read. And the better and more succinctly you can frame the questions which judges need to answer, the better they will be able to bring themselves up to speed. Remember, in trials, for argument's sake, the judge gets the file nowadays a couple of days beforehand. Sometimes, depending on when the trials are allocated, he or she might only get the matter the night before. And there isn't a great opportunity to bone up on what's there. So the practice note in that context is critical to know exactly where we're going. In appeals, of course, there's much more time to prepare, and practice notes help again. But if you bear in mind, as I've said a couple of times this evening, what the consumer of your advocacy needs from you, you will find it, I think, quite useful to use as a basis for designing how you approach the particular case, which will differ from court to court.
Thank you. There's a question from Bart Ford, or rather 2 questions. The first question is it necessary to state further an alternative relief in notices of motion? The second question is it necessary to state in an affidavit the following: where I make submissions of a legal nature, I do so on the advice of my legal representative, whose advice I verily accept to be correct?
Yeah. Well, there's no right or wrong answer to those questions. My own personal opinion is I think both of those statements are completely superfluous. Clearly, when a layman is making an affidavit, it's taken for granted that that layman has no legal knowledge. So if you have to say in your affidavit that I'm invoking a particular legal principle, or that I deny that the particular complaint or the particular relief that is sought by the adversary is feasible in law, it's not as if you're arguing the matter. And I think it's just precious to say that I referred to that on the basis of advice. I'm not really sure where it originated. It only arose some 15 years or so ago. So some clever fellow decided that they wanted to make a fuss about it, and then it got round that the way to eliminate the opponent making a fuss about allusions to law was to put this in. As a matter of being careful, it's become part of the fabric of practice, and I would leave it in simply because it's familiar, and it obviates the waste of time of some clever dick coming along and saying, aha, how can you say this? I want it struck out. So from a point of view of avoiding wasting time on tangential things, a little bit too much on that score is probably better than a little bit too less. As far as the further and alternative relief in notices of motion are concerned, that is important because, once again, you want to eliminate an argument from your adversary. Should you argue a judge exercise a discretion to give you something that's not foursquare within the prayers which you have sought? This is especially important in family matters. And so I would always have that in as a necessary ingredient. One of the complaints that can be raised in the absence of that is that I haven't prepared for any penumbra of relief that might be granted. And then, of course, simply in order to accommodate that complaint, which may or may not from some on occasion be sincere, you have further and alternative relief in, and then there can never be an interruption or a complaint that the judge might be asked to massage the relief to have something not radically different, but within the context of what the prayer set out.
Thank you so much, Justice. Justice Sutherland, there are many further questions. Unfortunately, time does not permit for such, and I have now closed the question and answer session. I now hand it back over to Acting Judge Ndambuleni to conduct the conclusion. Over to you, Acting Judge Ndambuleni.
Okay, thank you very much. Justice Sutherland, once again, thank you very much for your time. We know how busy you are, and this is one of among the best of the presentations that we have had due to the kind of the stature of a jurist that you are. We are very much thankful. We don't have to refer to Sydney Kentridge. You are here for us, and we thank you for giving us such a wonderful presentation today. And we thank you so much.
Thank you very much.
Thank you, Judge. What remains is to elaborate on what Acting Judge Ndambuleni has said. And yet again, sincerely thank you, Justice Sutherland, for his illuminating address and naturally as for his time. The South African Bar Association is indebted to you. We further thank Acting Judge Romeo Ndambuleni for his excellent welcome and conclusion, and obviously his time too. Appreciation to all those that have participated virtually and shall be watching this session at their leisure. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. I thank you.
Thank you very much. Good night.